Case 1, Lindsay Clancy. January 14, 2023. Plymouth County Superior Court, Duxbury, Massachusetts. There are communities along the South Shore of Massachusetts that carry a particular kind of quiet beauty. Towns where the Atlantic coastline shapes the rhythm of daily life, where children ride their bicycles through tree-lined streets in summer, and where neighbors exchange greetings across fences in the early morning. Duxbury is one of those communities. It is a town of roughly 18,000 people, located in Plymouth County, known for its historic character, its strong school system, and the kind of deeply rooted civic identity that takes generations to build. Families come to Duxbury because it feels safe, because it feels like the right place to raise children, because it offers the promise of stability, of community, of a life built on solid ground. It is in communities like this one, communities defined by that sense of safety and promise, that the sudden collapse of an ordinary family can hit with a force that extends far beyond the household where it occurred. Because when something goes deeply and irreversibly wrong inside a home that looked, from every external angle, exactly like what a good home is supposed to look like, it forces an entire community to ask questions that do not have easy answers. Questions about what was happening behind a door that appeared perfectly normal. Questions about whether the signs were there, and whether anyone could have read them clearly enough to act. Questions about what the systems and institutions that surround families are actually built to do, and what they are not built to do, even when the need is most urgent. Lindsay Clancy was 32 years old. She was a labor and delivery nurse at Brigham and Women's Hospital in Boston, one of the most respected medical institutions in the country, where she had spent years assisting in the arrival of new life, supporting families in their most vulnerable and most joyful moments, applying both technical skill and human compassion to work that demanded both. She was a mother herself. Her children were Cora, 5 years old, Dawson, 3 years old, and baby Callan, 7 months. Her husband, Patrick Clancy, was by all accounts a devoted partner and father. The family had a home on Summer Street in Duxbury. They had a life that, from the outside, carried every marker of the stability and warmth that the town itself was known for. The people who knew Lindsay in the period leading up to January of 2023 saw something different from that picture of stability. Those closest to her watched as she moved through the final months of 2022 in a state of increasing distress. Distress that was documented in her medical records, that had led her to multiple healthcare providers, and that had resulted in a prescribing regimen that, in retrospect, would become a central element of the legal and medical debate that followed. She had been seen by psychiatrists. She had been prescribed medications. The specific combination and dosage of those prescriptions would later be scrutinized intensely, not because anyone disputed that she had been receiving care, but because the question of whether that care had been adequate, appropriate, and sufficiently responsive to the severity of her condition would become one of the most consequential questions the case raised. Postpartum psychiatric illness exists on a spectrum. At one end is the well-documented and widely discussed experience of postpartum depression, a condition that affects roughly 1 in 5 new mothers, and that, while serious and deserving of proper treatment, is generally manageable with appropriate clinical intervention. At the other end of that spectrum sits postpartum psychosis, a condition that is far less common, affecting approximately 1 to 2 out of every 1,000 new mothers. But that is, in its acute form, one of the most severe psychiatric emergencies in all of medicine. Postpartum psychosis can arrive suddenly, sometimes within days of delivery, sometimes weeks or months later, and at its most extreme it can produce hallucinations, delusions, complete disconnection from reality, and behavior that is, in the fullest clinical sense, not under the patient's conscious control. Medical experts who reviewed the details of Lindsay Clancy's case would later describe her presentation in the weeks before January 14th as consistent with the acute phase of postpartum psychosis, a condition that, properly identified and treated, is also one of the most responsive to intervention. The window for preventing the worst outcomes, those experts noted, is real, but it requires early identification, aggressive clinical response, and a system of care equipped to recognize the difference between a mother who is struggling and a mother who is in crisis. On the evening of January 14, 2023, Patrick Clancy was away from the home briefly. When emergency calls began coming in from the Summer Street address, first responders arrived to find that the three Clancy children had been subjected to severe harm. Cora and Dawson did not survive. Baby Callan, just 7 months old, was transported to Boston Children's Hospital in critical condition. He survived. Lindsay herself sustained serious injuries after going through the rear of the home and falling from an elevated area. She was hospitalized and remained under medical supervision for an extended period. The charges that followed were among the most serious available under Massachusetts law. Prosecutors in Plymouth County filed charges of murder in connection with the passing of Cora and Dawson, and charges of attempted murder in connection with the harm to baby Callan. Lindsay Clancy, still recovering from her own injuries, was placed in a medical facility rather than a standard correctional institution, a decision that reflected the ongoing and acute nature of her psychiatric condition. Her defense, led by attorney Kevin Reddington, was built around a framework that most legal observers described as one of the most serious postpartum psychosis defenses ever mounted in Massachusetts. Reddington argued from the beginning that Lindsay had not been acting as herself, that on the night of January 14th, she had been entirely consumed by a psychiatric emergency so profound and so documented in her medical history that applying conventional criminal responsibility to her actions was not legally or medically appropriate. The defense pointed to the specific medications she had been prescribed, some typically reserved for patients with far more acute and long-standing psychiatric conditions, and argued that the medical system overseeing her care had been presented with clear warning signs and had failed to act on them with sufficient urgency. The prosecution's position was not that Lindsay's mental health history was irrelevant. It was that the legal standard for a not guilty by reason of insanity finding required demonstrating a specific kind of incapacity, the complete inability, at the precise moment of the act, to understand its wrongfulness, and that the evidence did not unambiguously establish that standard had been met. The case was, in the most direct possible sense, a collision between the law's existing framework for criminal responsibility and the medical reality of a condition that does not map neatly onto that framework. Patrick Clancy, who lost 2 of his children and whose wife was now facing the most serious criminal charges in the Massachusetts system, became one of the most discussed figures in the public narrative surrounding the case. He spoke publicly about Lindsay with love and clarity, expressing his view that the medical system had failed her and that her actions were the product of illness, not malice. His position was not universally shared by those who followed the case, but his willingness to hold his grief and his love simultaneously, in public, in the immediate aftermath of an unimaginable loss, gave the case a human dimension that no legal filing could have provided. As this documentary was produced, the case of Lindsay Clancy remained active in Plymouth County Superior Court. Trial proceedings had been scheduled and adjusted multiple times as both sides continued building their respective cases. The psychiatric evidence, the medical records, the expert testimony, the clinical analysis of her condition in the weeks and months before January 14th remained at the center of the legal proceedings and at the center of a national conversation about maternal mental health that the case had ignited and that showed no sign of quieting. That conversation matters. It matters because postpartum psychosis is real, it is treatable, and it is far more common than the medical system's response to it has historically reflected. It matters because the warning signs were present in Lindsay Clancy's case, documented in records, visible to providers, communicated by a family watching her unravel, and because those warning signs did not trigger the level of intervention that might have changed the outcome. It matters because Cora Clancy was 5 years old and Dawson Clancy was 3 years old, and baby Callan survived something that no 7-month-old should ever have to survive, and their story does not belong only to the legal system that is now deciding how to process it. It belongs to every conversation about what it means to actually support mothers in the postpartum period, not with platitudes, not with inadequate follow-up appointments, but with the full weight of clinical attention that the most serious cases demand. Cora Clancy and Dawson Clancy are remembered here with dignity and with care. Their lives were real. Their story is told because it demands to be told, not to exploit the pain of a family that has already lost more than most families can imagine, but because the systemic failures that preceded January 14th, 2023, deserve to be examined clearly and honestly so that another family does not have to endure what the Clancy family endured. If you or someone you love is experiencing postpartum depression, postpartum anxiety, or any sign of postpartum psychiatric distress, please reach out immediately to Postpartum Support International at 1-800-944-4773. Help is available. Early intervention saves lives. You do not have to manage this alone. If this case moved you, if it made you think about the mothers in your own community, please take a moment right now to like this video. Your support makes sure these stories reach the people who need to hear them. Hit that subscribe button. It costs nothing and it means everything to this community. Case 2. Erica Murray. August 25, 2014. Worcester County Superior Court, Blackstone, Massachusetts. Worcester County sits in the geographic heart of Massachusetts, a broad and varied region that contains some of the state's most historic industrial towns, its most rural communities, and a population that has always prided itself on a particular kind of New England resilience. It is a region where people work hard, where neighbors tend to maintain a respectful distance from one another's private affairs, and where the rhythms of community life carry the familiar textures of towns that have been in place for centuries. Blackstone is one of those towns, a small mill community pressed against the Rhode Island border, a place where the architecture still carries echoes of its industrial past, and where the streets feel, on most days, entirely ordinary. For years, a house on Spindle City Road existed at the edge of Blackstone's community awareness. Not invisible, neighbors had noticed things, over time, that registered at least partially as concerning. An odor that had become familiar enough to stop prompting action. A property that had fallen into significant disrepair. Children whose faces were occasionally glimpsed through windows, but who did not seem to participate in the normal patterns of childhood in the neighborhood, who did not attend school in the expected way, who did not play outside with other children, who did not exist in the ordinary social fabric of the street in the way that children who are being properly cared for typically do. The town around that house continued its ordinary life. And whatever was happening behind that door continued as well. What investigators and child welfare workers found when they entered the Spindle City Road property on August 25, 2014, represented one of the most significant child welfare emergencies in the history of Worcester County. The investigation had been prompted by a tip, the kind of community-generated alert that the child welfare system depends on, and that, in this case, finally moved the situation from the category of neighborhood concern to the category of official response. 4 living children were recovered from the home that day. Their conditions, documented by medical personnel in the hours and days that followed, reflected the effects of severe and prolonged neglect. They were malnourished. Their physical development had been compromised by years of inadequate nutrition and care. Their social and developmental needs had gone unmet for periods of time that left marks that would require sustained professional support to begin to address. The youngest among them had grown up in an environment that first responders described as among the most hazardous residential conditions they had encountered in their professional experience. Inside the structure, investigators also discovered what forensic examination would later confirm to be the remains of 3 infants. The presence of those remains, the questions surrounding how those children had arrived in the world, how they had passed from it, and how they had come to remain inside that house for what forensic analysis suggested had been a significant period of time, became the focus of a criminal investigation that would take years to move through the Worcester County court system. Erica Murray was 31 years old at the time of her arrest. Her partner, the father of several of the children, was also investigated and faced charges in connection with the conditions inside the home. Murray was charged with multiple serious offenses, including charges related to the infant remains found on the property and to the documented condition of the 4 children who had been recovered alive. The legal proceedings that followed were extensive and complex. The physical evidence required detailed forensic analysis. The timeline that prosecutors were attempting to establish, the sequence of events that would explain how 3 infants had come to be present in that home and in those circumstances, was constructed painstakingly over the course of years. Questions about Murray's mental state, about the specific circumstances of each infant's passing, and about the precise legal standard required for the most serious charges all shaped the way the case moved through the system. In the end, Murray was acquitted of the charges related to the infant remains. The prosecution was unable to establish, beyond the legal threshold of reasonable doubt, the specific circumstances of those passings in a way that supported the most serious charges. But she was convicted of assault and battery on a child, a charge that reflected the documented harm done to the living children recovered from the home, and of animal cruelty, reflecting conditions found on the property that extended to animals kept there. The sentence she received was substantial. But for the investigators and child welfare professionals who had spent time inside that Blackstone property, the legal outcome could only partially address the full weight of what they had witnessed. The case prompted a serious and sustained examination of how the child welfare system in Worcester County, and in Massachusetts more broadly, identifies and responds to signs of severe neglect in private residential settings. The question of how 4 children could develop in those conditions without triggering a definitive intervention from schools, medical providers, neighbors, or extended family became a central focus of that examination. Mandatory reporting requirements were reviewed. Training protocols were assessed. The obligations of community members who observed signs of concern were discussed at a level of specificity that the case demanded. The children recovered from Spindle City Road were placed in protective custody and entered the foster care and adoption system. Social workers who monitored their progress in the years that followed documented recoveries that were long and difficult, which is what recovery from severe early deprivation always looks like, but also real. Children who have been denied the foundations of healthy development are capable of extraordinary resilience when they are given consistent, patient, specialized support. That resilience, documented in the case records of those 4 children, is the only genuinely hopeful thread in an otherwise devastating story. The 3 infants whose remains were found inside that home never received the chance to be known by the world. They are remembered here as real lives. Lives that began and ended within a context of profound failure by the adults who should have been responsible for them, and by a community whose collective failure to act decisively earlier was part of how this situation persisted for as long as it did. Accountability in this case was incomplete, as it must be when the most serious charges cannot be proven to the legal standard required. But the systemic response, the reviews, the protocol changes, the conversations about what community members and institutions owe to children they are concerned about, represents a form of accountability that extends beyond any individual verdict. It represents a commitment, however imperfect, to making sure that a situation like the one on Spindle City Road is harder to sustain undetected in the future. If you are ever concerned about the welfare of a child in your community, please do not hesitate. Contact the Massachusetts Department of Children and Families hotline at 1-800-792-5200. The call is confidential. It could be the most important call you ever make. Please take a moment to like this video. These children deserve better. Sharing their story is how we make sure the community conversations they deserve actually happen. Case 3, Carolyn Riley. December 2006, crime. April 22, 2010, conviction. Plymouth County Superior Court, Hull, Massachusetts. Hull is a narrow peninsula community on the south shore of Massachusetts, a strip of land that juts into Boston Harbor, bounded by water on nearly every side. A place where the sound of the ocean is a constant presence, and where the tight geography of the town creates a particular kind of community closeness. It is the kind of place where people notice each other, where the rhythms of daily life, school drop-offs, grocery runs, walks along the seawall, bring the same faces into contact with each other repeatedly, building the kind of familiarity that, in ordinary circumstances, forms the connective tissue of a healthy neighborhood. The Riley family lived in Hull. They were part of that community fabric in the way that families in small peninsula towns inevitably are. Carolyn Riley and her husband Michael had children. Their youngest, Rebecca, was by all external appearances a child being raised in an environment that included medical attention. Perhaps more medical attention than one might expect for a child of her age, but medical attention nonetheless. Rebecca had been seen by psychiatrists. She had received diagnoses. She had been prescribed medications. The documentation of her care, examined in retrospect, would become one of the most disturbing elements of the case that eventually emerged from Hull, not because it showed neglect, but because it showed something in some ways more troubling than neglect. It showed a system that had been manipulated. Rebecca Riley was 4 years old. In December of 2006, Rebecca did not wake up. Emergency responders called to the Riley home found the child unresponsive. She was transported immediately to medical care and was pronounced to have passed shortly after arrival. The medical examination that followed identified the cause as an overdose of prescription psychiatric medication that had been prescribed to Rebecca by a psychiatrist who had been working with the family, medication that the forensic and toxicological analysis determined had been present in her system at a level far exceeding any legitimate therapeutic purpose. The investigation that unfolded in the weeks and months following Rebecca's passing reconstructed, with methodical and devastating precision, what had been happening in the Riley household. The picture that emerged was of a pattern in which Rebecca's alleged psychiatric conditions, diagnoses that included serious disorders not typically identified in children as young as she was, had been presented to medical providers in ways that, investigators concluded, were designed to obtain prescriptions rather than to accurately convey a child's genuine clinical needs. The medications obtained through that process had then been administered in a manner inconsistent with any legitimate medical management of the conditions they were supposedly treating. The prosecution's case, presented to a jury in Plymouth County Superior Court, rested on the argument that what had been done to Rebecca was not the result of confusion, misunderstanding, or parental anxiety. It was deliberate. The quantities and combinations involved, according to medical experts called during the trial, pointed away from accidental mismanagement and toward intentional administration for a purpose that had nothing to do with Rebecca's health. Carolyn Riley was charged with second-degree murder. Michael Riley, her husband, faced the more serious charge of first-degree murder in separate proceedings that ran in parallel. The legal distinction between the charges they each faced reflected the jury's and the court's respective assessments of their individual levels of premeditation and direct involvement. Carolyn was convicted of second-degree murder on April 22, 2010, and sentenced to life in prison with the possibility of parole. Michael was convicted of first-degree murder and received a sentence of life without the possibility of parole. The case generated a significant and sustained secondary discussion about the clinical decisions made by the medical providers who had been involved in Rebecca's care, not as a matter of criminal culpability, but as a matter of systemic accountability. How had a child of 4 years old come to be on a pharmaceutical regimen of this kind? What safeguards existed in the prescribing system to prevent it from being manipulated in the way the prosecution argued it had been manipulated here? What obligations did providers carry when a parent's account of a child's symptoms seemed to escalate in ways that drove prescriptions rather than clinical observation driving them? These questions did not have simple answers. The medical community's response to the Riley case included serious internal conversations about the prescribing of complex psychiatric medications to very young children, about the protocols for verifying parental accounts of symptoms against direct clinical observation, and about the warning signs that might indicate a parent was seeking medication for purposes other than the child's welfare. Massachusetts subsequently strengthened protocols in this area, requiring additional layers of clinical review before complex psychiatric medications could be maintained for children below certain ages. Those changes came after Rebecca Riley had already lost her life. That is the frustrating and irreducible truth of systemic reform in cases like this one. It happens after, not before. It happens because a child's story forces the conversation that should have been happening all along. Rebecca Riley was 4 years old. She did not have the vocabulary to describe what was happening to her. She did not have the capacity to understand that the adults presenting her care to the world as medical management were doing something else entirely. She trusted, in the absolute and unconditional way of a 4-year-old, that the people responsible for her were acting in her interest. That trust was catastrophically misplaced. The accountability that followed her passing, 2 convictions, 2 life sentences, protocol changes, professional soul-searching, is real. It is also insufficient, because no accountability can restore what Rebecca Riley lost. But it is recorded in the permanent history of Plymouth County, and in the permanent memory of a community that learned something devastating about what can happen when a child's vulnerability is exploited rather than protected. Rebecca Riley's story is told here because she deserves to be remembered, not as a case file, not as a footnote in a discussion about prescribing protocols, but as a 4-year-old girl who deserved to grow up and who was failed by every layer of the system that should have kept her safe. If you are concerned that a child in your life may be experiencing harm related to medical mismanagement or any form of abuse, please contact the Child Help National Child Abuse Hotline at 1-800-422-4453. Trained counselors are available every hour of every day. Please like this video. Rebecca Riley's story deserves to be heard. Your subscription helps make sure it reaches every person who needs to hear it. Case 4, Rochelle Bond. June 25, 2015. Suffolk County Superior Court, Boston, Massachusetts. Boston is a city that knows how to hold grief collectively. It is a city with a long memory and a deeply felt sense of communal obligation. A place where the loss of a child, when it becomes public, is not processed privately, but is absorbed into the broader conscience of the community in a way that is palpable and real. When a child is lost in Boston, the city feels it. When that child has no name and no one has come forward to claim her, the city feels something else, a particular kind of moral urgency, the quiet but insistent refusal to accept that a child can exist and then simply stop existing without anyone caring enough to notice. On June 25, 2015, a child was discovered on Deer Island in Boston Harbor. She was a toddler, female, approximately 2 to 3 years of age, wearing polka dot leggings. She had been in the water. Her condition made identification through standard means impossible. No one had reported her missing. No Amber Alert had been issued. No parent had come forward. She arrived on that island shoreline as someone whose existence had been entirely invisible to the official systems designed to track and protect children. A child who had been living in the world and had then stopped, and whose absence had not, until that morning, prompted a single formal inquiry from anyone responsible for her welfare. Law enforcement named her Baby Doe. A forensic artist created a composite reconstruction of her face, an image built from science rather than from memory, because the people who should have known her face were not speaking. Boston Police and the Massachusetts State Police released that image widely, asking the public for help in identifying a child who, in death, had no name. The response was unlike almost anything that Boston law enforcement had experienced. The composite image traveled across social media platforms with a speed and reach that reflected not casual sharing, but something closer to collective moral action. Hundreds of thousands of people shared it. Millions saw it. The message was clear and it was felt. Someone knew who this child was, and the public was not going to stop until they came forward. The idea that a toddler could simply vanish from the world without anyone in her life raising an alarm was something that people, across every demographic and community in Greater Boston, refused to accept as something they could simply scroll past. Within weeks, the tips began coming in. DNA analysis confirmed the identity. The little girl in the polka dot leggings was Bella Bond. She was 2 years old. She had been living in a Boston apartment with her mother, Rochelle Bond, and her mother's boyfriend, Michael McCarthy. What the investigation documented in the weeks that followed was a picture of Bella's final months of life that investigators described as marked by severe harm inflicted in the home where she was supposed to be safest. The forensic analysis established the nature and extent of what Bella had endured. It also established the timeline, the sequence of events from the harm that ended her life to the decision by the adults in the home not to seek help, not to call anyone, not to report what had happened, but instead to take Bella's body and place it in the waters of Boston Harbor, where they evidently believed she would never be found or identified. Michael McCarthy was charged with first-degree murder in connection with Bella's passing. The prosecution established that McCarthy had been the direct perpetrator of the harm that ended her life. He was convicted and sentenced to life in prison without the possibility of parole. Rochelle Bond's role was different in legal terms, though not in moral ones. Investigators established that Bond had been aware of what was happening to her daughter, that she had not been an absent or oblivious presence during the period of harm, but had been present, had known, and had failed to act in the way that any parent is both legally and morally obligated to act when their child is in danger. After Bella's passing, Bond had participated in the concealment, had helped ensure that her daughter's body was placed in the water, had said nothing to anyone, had not reported Bella as missing, and had continued her daily life while her 2-year-old daughter floated in Boston Harbor for weeks. Bond pleaded guilty to being an accessory after the fact in the passing of her daughter. In exchange for her guilty plea and her cooperation as a witness against McCarthy, She received a sentence that resulted in her serving approximately 2 years in custody before being released. The legal system drew a clear line between Bond's culpability and McCarthy's, a line that reflected the specific charges available under Massachusetts law and the evidentiary agreements that shaped the plea negotiation. That line was, for many people who followed the case, an extremely difficult one to accept. The moral weight of a mother's failure to protect her child, combined with her active participation in concealing that child's passing, produced a public conversation about the limits of what the law can reach and what it cannot. Bella Bond was 2 years old. She had not yet developed the full vocabulary of a 2-year-old. She was at the age when children are beginning to understand that they are separate people, when the world is starting to come into focus as a place with patterns and routines and faces they recognize and trust. She had no means of protecting herself. She had no means of understanding why the adults in her home were not protecting her. The composite image of her face, reconstructed by science because the people who actually knew her face were not speaking, became one of the most widely shared images in the history of Boston journalism and one of the most enduring symbols of a child who deserved better in every possible way. Bella Bond is not a cold case. Her story has been told in books, in documentaries, in legal scholarship, and in the ongoing work of child welfare advocates who use her case to illustrate what happens when every layer of protection that should exist around a vulnerable child fails simultaneously. She is remembered here not because her story needs to be amplified for its sensational elements, but because she was real, she mattered, and the systems that failed her are still in operation, serving other children who deserve better outcomes than she received. Justice for Bella was partial, and it was hard-won. Michael McCarthy will not leave prison. Rochelle Bond served 2 years. Whether those outcomes fully answer the question of what Bella Bond was owed is something each person who hears her story will have to reckon with individually. If you are concerned about the welfare of a child, please do not wait. Contact the Massachusetts Department of Children and Families at 1-800-792-5200. Bella Bond's story is a reminder that the call you are hesitating to make could be the one that changes everything. Please like this video. Bella Bond deserved to be found. She deserved to be remembered. Your support helps make sure she is never forgotten. Case 5. Louise Woodward. February 4, 1997. Middlesex County Superior Court, Newton, Massachusetts. Newton, Massachusetts is a city of villages, a collection of distinct neighborhoods just west of Boston, connected by tree-lined streets and a shared reputation for strong schools, professional families, and the kind of settled suburban comfort that attracts people who are building something long-term. It is a city where children are visible in the ordinary ways, at parks, at school crossings, in the back seats of cars headed to weekend activities, and where the care of those children is understood as a fundamental community value, something that goes without saying because it is simply part of how the place operates. In the autumn of 1996, a young woman named Louise Woodward arrived in Newton from Cheshire, England. She was 18 years old. She had come to work as an au pair for the Eapen family, Sunil Eapen, an anesthesiologist, and Deborah Eapen, an ophthalmologist. The Eapens had 2 sons. The elder was not yet 2 years old. The younger, Matthew, was 8 months old. The arrangement was a practical one, of a kind that thousands of professional families across the United States entered into every year. A young person from another country, living in the home, responsible for the daily care of young children while their parents maintained demanding careers. On the evening of February 4, 1997, Louise Woodward placed a call to emergency services reporting that 8-month-old Matthew Eapen had become unresponsive. Paramedics arrived and found the infant in critical condition. Matthew was transported to a hospital and placed on life support. He did not survive. He passed away on February 9, 5 days after the emergency call, from a head injury that the medical examiner and treating physicians determined was the result of severe physical trauma that, the medical evidence suggested, was not consistent with an accident. Woodward was arrested and charged with murder. She maintained throughout that she had not intentionally harmed Matthew, that she had been frustrated on that evening, that she had handled him in a way she described as firm or rough, but that she had not done anything that she understood as dangerous. Her defense presented a series of alternative medical theories during the trial, including the argument that Matthew may have had a pre-existing injury that had been re-aggravated, rather than a fresh injury caused solely by Woodward's actions on the night of February 4th. The medical debate at the center of the Woodward trial became one of the most extensively covered courtroom scientific controversies of the 1990s. Expert witnesses on both sides presented interpretations of the forensic and neurological evidence that were sharply contradictory. The prosecution's experts maintained that the nature and severity of Matthew's injury were consistent with deliberate violent action. The defense's experts maintained that the evidence was more ambiguous, that the existing science could not definitively rule out the alternative injury timeline they were proposing. The jury heard all of it. They deliberated. And in October of 1997, they returned a verdict of guilty on the charge of second-degree murder. The reaction to that verdict was immediate and internationally dramatic. In the United Kingdom, where Woodward had become a figure of significant public sympathy, the conviction was received as a miscarriage of justice, as the story of a young woman who had traveled abroad for an ordinary working experience and been trapped in an American legal system that had been looking for someone to blame. Protests and vigils took place in England. Political figures commented. The coverage was intense and sustained. In Massachusetts, the reaction was divided. For Sunil and Deborah Epen, the conviction represented the legal system's acknowledgement of what they had experienced, the loss of their 8-month-old son and their certainty, as his parents and as medical professionals themselves, about the nature of what had caused that loss. For others who had followed the trial closely, the medical complexity of the case and the youth of the defendant produced genuine uncertainty about whether the verdict reflected the full truth of what had happened in that Newton home. What happened next added another layer of extraordinary complexity to a case that already had more than most. Judge Hiller Zobel, who had presided over the trial in Middlesex County, invoked a legal mechanism available under Massachusetts law to reduce Woodward's conviction from second-degree murder to involuntary manslaughter. He sentenced her to time already served, 279 days, and ordered her release. In his written ruling, Zobel explained that while the evidence supported a finding that Woodward had caused Matthew's injury, it did not support the level of malice required for a murder conviction. Manslaughter, in his assessment, more accurately captured what the evidence established. The reaction to Zobel's ruling was as intense as the reaction to the original verdict. In England, the decision was celebrated. In Massachusetts, legal scholars debated the appropriateness of judicial reduction of a jury verdict, with many arguing that Zobel had overstepped the boundaries that properly separate judicial and jury functions. Deborah Epen spoke publicly about the ruling with a depth of pain that was evident in every word, describing it as a second loss, a second moment in which the legal system had produced an outcome that felt, to her, as Matthew's mother, like a failure to fully recognize what had been taken from her family. Louise Woodward returned to England. She eventually completed a law degree, married, and built a private life largely removed from the public attention that had defined 1997 for her. She has spoken periodically in interviews about her experience, but has not maintained a significant public profile. Matthew Epen was 8 months old. He had learned to recognize faces. He responded to voices. He was at the very beginning of the long process of becoming a person, a process that was ended in a Newton home on a February evening in 1997. His parents became advocates for child safety in the years that followed. The case they lived through influenced how infant head trauma cases are investigated, how expert testimony in such cases is evaluated, and how the au pair industry screens and trains the young people it places in homes with very young children. The legacy of the Woodward case is a complicated one. It did not resolve the medical debate at its center. It did not produce an outcome that everyone who followed it accepted as just. What it did produce was a sustained public examination of how the law handles cases where the evidence is genuinely ambiguous, where the accused is young and frightened and far from home, and where the victim is a child too young to have any voice in what is being said about him in a courtroom. Matthew Epen is remembered here because he was real, because his 8 months of life deserved the decades that followed, because his parents' grief, documented across years of public advocacy, is a testament to the fact that he was loved and that his loss was total. Please like this video. Matthew Epen's story is one that the true crime community owes it to him to tell with care and with honesty. Case 6, Julie Corey. August 27, 2009, crime. October 31, 2014, Conviction. Worcester County Superior Court, Worcester, Massachusetts. Worcester is the second largest city in Massachusetts, a place of gritty industrial history, enormous institutional presence, and a population that has always carried a particular kind of no-nonsense civic identity. It is a city of neighborhoods, of triple-deckers and corner stores, of university students and longtime residents whose families have been in Worcester for generations. It is a city that, like all cities of its size and character, carries within it both the full range of human connection and the full range of human tragedy. And in the late summer of 2009, it became the location of a crime so profoundly disturbing that it drew national attention and has since been used as a reference point in law enforcement training, forensic psychology research, and child safety advocacy across the country. Darlene Haynes was 23 years old. She was 7 months along in her pregnancy, close enough to her due date that the preparations she had been making for her child's arrival were real and specific. She had plans. She had a name for her baby. She had been building toward the moment of her daughter's arrival with the kind of quiet, particular excitement that characterizes the final weeks of a pregnancy when everything is nearly ready. She lived in a Worcester apartment building where neighbors described her as warm and approachable, someone who engaged with the people around her, who was known and liked, whose presence on the floor was felt as a genuinely positive one. On August 27, 2009, Darlene stopped being seen. It was not an immediate alarm. People disappear from their regular patterns for all sorts of ordinary reasons, and the initial concern among those who noticed her absence was low-level, the kind of mild worry that prompts someone to knock on a door or send a message. When those attempts to reach her went unanswered, the concern escalated. When it escalated enough that someone checked on her directly, what they found inside her apartment set off an investigation that would shake Worcester County to its foundation. Darlene Haynes had been the victim of targeted violence. She had not survived, and the infant she had been carrying, 7 months developed, close to viable outside the womb, had been taken from her by the person who had harmed her. The investigation that followed moved quickly in the way that investigations with specific, urgent biological evidence tend to move. A living infant was somewhere. That infant needed to be found. The trail led to Connecticut within 2 days. At a homeless shelter in the neighboring state, a woman had arrived with a newborn, presenting herself as the child's mother, describing a recent birth, requesting assistance for herself and for the baby. The story she told was consistent and confident. The staff at the shelter, operating without any reason at that moment to question the account they were being given, provided the requested assistance. That woman was Julie Corey. She was 30 years old. She had a prior relationship with Darlene Haynes. The nature of that relationship and the timeline of Corey's movements in the period leading up to August 27th became central elements of the prosecution's case against her. When Massachusetts investigators contacted Connecticut authorities with the information they had developed about a missing infant connected to the Worcester investigation, Corey was located and taken into custody. The infant, Darlene's daughter, was recovered. She was alive. She was in reasonably stable condition. In the context of everything else that surrounded her arrival in the world, the fact that she was alive and recoverable was the only element of the story that did not require grief to receive. Julie Corey was charged with first-degree murder in the passing of Darlene Haynes. The case moved slowly through the Worcester County court system. Questions about Corey's competency to stand trial and her mental state required extensive evaluation and produced delays that stretched the proceedings across multiple years. It was not until October 31, 2014, more than 5 years after Darlene's passing, that Corey was convicted. She was sentenced to life in prison without the possibility of parole. Darlene's daughter, the baby who had been taken from her in the most violent and incomprehensible circumstances imaginable, was placed in the care of family members who knew the full circumstances of her birth and who committed to raising her in a safe and loving environment. Reports in the years that followed indicated that she was growing up in a stable home, surrounded by people who loved her and who were determined to give her the life that Darlene had been preparing to provide. The Corey case is studied in law enforcement and forensic psychology programs as an example of a specific pattern of criminal behavior, fetal abduction, that, while statistically rare, has occurred in the United States with enough frequency that the FBI and state law enforcement agencies have developed specific investigative and response protocols. Cases that fit this pattern share recognizable characteristics. A perpetrator who has claimed to be pregnant, who has cultivated a relationship with the victim, and who has acted on a premeditated plan with a specific goal. Understanding the pattern helps investigators recognize and respond to these cases more quickly. The development of those protocols, motivated in significant part by cases like the one in Worcester, has accelerated the resolution of subsequent incidents and, in some cases, resulted in the recovery of infants who might otherwise not have survived. Understanding the pattern does not make it easier to process the individual case. Darlene Haynes was 23 years old. She was a person whose life had value and whose future had potential. She was a mother who did not get to meet her daughter in the way she had spent months imagining and preparing for. She did not get to hold her in a hospital room. She did not get to take her home. The life ahead of her, the ordinary, particular, irreplaceable life that was hers, was ended by someone who had decided that Darlene's existence was less important than what Darlene was carrying. The conviction of Julie Corey and her sentence of life without the possibility of parole represent the full weight of the justice system's response to what she did. That response was real and it was significant. Darlene Haynes is remembered here because she was more than a case number. Because her daughter deserves to know, as she grows up, that people remember who her mother was and why her story matters. And because the accountability that followed Darlene's passing, however long it took to arrive, was not just a legal formality. It was a statement, recorded permanently in the courts of Worcester County, that Darlene Haynes was valued, that her life mattered, and that what was taken from her was recognized and answered. If you or someone you know is in an unsafe situation or relationship, please reach out to the National Domestic Violence Hotline at 1-800-799-7233. Confidential support is available every hour of every day. Please like this video. Darlene Haynes deserved so much more than what she received. The least we can do is make sure her story is never forgotten. Case 7, Latarcia Sanders. November 2, 2018, crime. September 22, 2022, conviction. Plymouth County Superior Court, Brockton, Massachusetts. Brockton is a city that has always known how to carry weight. It is a city of roughly 100,000 people in Plymouth County, a former manufacturing center that reinvented itself when the factories closed, that absorbed wave after wave of immigrant communities and built something new out of the combination, that produced world champion boxers and community leaders and ordinary people of extraordinary resilience. Brockton is proud of what it has endured and what it has built. It is a city with a strong sense of itself, a strong sense of community obligation, and a strong sense of what is owed to the children who grow up within its borders. When emergency services were called to a residence in Brockton on the morning of November 2, 2018, what officers found inside represented a loss that the community would carry for years. Jordan Sanders was 8 years old. Jalen Sanders was 5 years old. Both boys had been subjected to severe harm inside the home. Neither survived. Their mother, Latarcia Sanders, was located at the scene and taken into custody. From the earliest stages of the investigation, the case that would take shape around Latarcia Sanders was shaped by a question that the legal system is never fully equipped to answer simply. What does a person's mental state at the moment of a devastating act tell us about their criminal responsibility for it? It is a question that has occupied courts, psychiatrists, legal scholars, and ethicists for as long as the insanity defense has existed in American law. And in the case of Latarcia Sanders, it was a question that would be argued before a Plymouth County jury in proceedings that stretched across 4 years from the event to the verdict. The defense built its case around Latarcia Sanders' psychiatric history. Evidence was presented about the mental health challenges she had faced in the period leading up to November 2nd. Challenges that, defense attorneys argued, had escalated in the days immediately preceding that morning into an acute psychiatric crisis that had rendered her, in the clinical and legal sense, unable to understand the nature or wrongfulness of her actions. The defense argued that this was not a case of deliberate, calculated criminal behavior, but of a woman in the grip of a psychiatric emergency so severe that the conventional framework of criminal accountability could not fairly be applied to her. The prosecution acknowledged the mental health component of the case. What they maintained was that the Massachusetts legal standard for a finding of not guilty by reason of insanity, a standard that requires demonstrating a complete absence of capacity to understand right from wrong at the specific moment of the act, had not been established by the evidence before the jury. The physical evidence, the circumstances of the event, and the behavioral record surrounding it, they argued, were consistent with a level of awareness and intent that met the legal threshold for criminal responsibility. The jury deliberated carefully. They returned guilty verdicts on 2 counts of first-degree murder. Latarcia Sanders was sentenced to 2 consecutive terms of life in prison without the possibility of parole, the maximum sentence available under Massachusetts law. The verdict and the sentence produced a range of responses that reflected the genuine complexity of the case. Mental health advocates who had followed the proceedings closely argued that the outcome was a failure of both the mental health system and the criminal justice system, that a woman who had been showing signs of serious psychiatric deterioration had not received the intervention she needed before November 2nd, and that incarcerating her for life without addressing the mental health crisis at the root of the tragedy was a response more focused on punishment than on the prevention of future harm or the treatment of someone whose illness had been catastrophically undertreated. Those arguments had genuine merit and genuine force. They did not change the facts of what Jordan and Jalen Sanders had lost. Jordan was 8 years old. He was at an age when children are beginning to understand who they are in the world, when the personality that will carry them through the rest of their life is taking on a definite shape, when friendships and interests and private thoughts begin accumulating into something that will eventually be a fully formed adult. He did not get to complete that process. Jalen was 5 years old. He was at the very beginning of school, at the age when the world is enormous and full of things that have not yet been explored. He had decades ahead of him. He did not get to access them. Both boys deserved protection. Both boys were entitled to the full and unobstructed experience of growing up. The community in Brockton that learned what had happened on November 2nd responded with the grief and solidarity that communities express when children are lost. Vigils, collective mourning, the palpable weight of a shared loss that does not resolve, but that signals an understanding of what had been taken. The mental health system failed Latarcia Sanders before November 2nd. That is a statement that can be made honestly and specifically based on the evidence presented during her trial. The criminal justice system found her guilty of the worst crime the law recognizes. Both of those things are true simultaneously. Holding that complexity honestly, acknowledging the systemic failure without allowing it to displace the weight of what was done to 2 children, is the only way to respond to a case like this one with the seriousness it demands. Jordan Sanders and Jalen Sanders are remembered here. They were real. They mattered. They deserved decades they did not receive. Their story is told with the respect and care that their brief time on this earth was always worth. If you or someone you know is experiencing a mental health crisis, please reach out to the National Alliance on Mental Illness Helpline at 1-800-950-6264. Help is available, and seeking it is never a sign of weakness. Please like this video. Jordan and Jalen Sanders cannot tell their own story. We can make sure the world does not forget it. Case 8, Shauna Pedroso. 2018, crime. March 2022, sentencing. Worcester County Superior Court, Fitchburg, Massachusetts. Fitchburg is a small city in the northern reaches of Worcester County, a former industrial community built around the paper and textile mills that once defined its economy, a place whose residents carry a deep attachment to their city's history and a deep investment in its future. Like many post-industrial New England cities, Fitchburg has faced the challenges of economic transition with a particular kind of stubborn civic pride. Its neighborhoods are tight-knit. Its schools are central to the community's sense of itself. And when harm comes to a child within its borders, it registers as a wound that the entire community feels. Sophia Pedroso was 6 years old. She was at the age when school defines the structure of every week, when classroom friendships are forming, when reading is becoming real, when the world is beginning to reveal its dimensions in ways that feel new and exciting every day. She should have been experiencing exactly that. She should have been doing all of it. Instead, she had been living in circumstances that investigators, through the evidence they assembled in the course of their investigation, determined had involved severe and sustained harm within the home where she was supposed to be most protected. When emergency services were called to a Fitchburg residence in 2018, the adults present, Sophia's mother, Shauna Pedroso, and Sophia's father, Felipe Pedroso, had a story ready. They told investigators that Sophia and another child had been in nearby woods when they were confronted by older children, adolescents who had subjected them to serious harm before fleeing the area. The account was detailed. It was presented with the kind of urgency and distress that one would expect from parents whose child had been seriously harmed by strangers. It was the kind of story that, if true, would have immediately redirected a significant law enforcement response toward finding the perpetrators in the woods. Investigators listened carefully. They also looked carefully at everything the evidence was telling them. And what the evidence was telling them did not match the story they were hearing. The nature and pattern of the harm Sophia had sustained was not consistent with an assault by peer-aged children in an outdoor setting. The forensic picture that emerged from the medical examination pointed in a different direction entirely, toward harm inflicted by adults, in an enclosed space, with a force and deliberateness that no account involving teenage bullies in nearby woods could accommodate. As investigators pressed further and the physical evidence was analyzed in detail, the narrative constructed by Sophia's parents collapsed under its own inconsistencies. Shauna Pedroso ultimately entered a guilty plea to second-degree murder in connection with the passing of her daughter Sophia. The guilty plea resolved the case without a full trial, sparing witnesses and family members from a lengthy and detailed courtroom proceeding, but also foreclosing a complete public accounting of the specific events inside the Fitchburg home. She was sentenced in March of 2022. Felipe Pedroso faced separate charges and proceedings in connection with Sophia's passing. The deliberate fabrication of the Woods assault story, the constructed false account designed to redirect the investigation away from the home and toward a fiction, was one of the most discussed elements of the case in both law enforcement and public circles. It was not a spontaneous attempt to deflect suspicion. It was a prepared story, with detail and internal consistency, delivered to investigators in the immediate aftermath of an emergency call. The effort that had gone into constructing that story pointed toward a clear understanding by the adults who delivered it that what had happened to Sophia inside the home was something that required concealment, that it could not survive scrutiny if the investigation pointed in the right direction. The story did not hold. It did not hold because investigators are trained to look at what evidence shows rather than what accounts claim. It did not hold because the forensic picture of what had happened to Sophia was inconsistent with the fiction being offered to explain it. And it did not hold because the legal and child welfare systems, however imperfect and however slow, eventually arrived at the truth of what had occurred in that Fitchburg home. Sophia Pedroso was 6 years old. She had a classroom. She had a teacher. She had a school building full of adults whose professional lives were built around exactly the kind of support and protection that she had a right to receive. The adults in her home had built a story designed to ensure that the truth of her passing was never discovered. That story failed. The truth was found. And Sophia's story is now part of the permanent record of Worcester County, a record that states clearly that she existed, that she mattered, and that what was done to her and what was done afterward to conceal it were recognized, investigated, and answered by the full weight of the law. Children who are being harmed at home often show signs that the adults around them, teachers, counselors, coaches, neighbors, are positioned to notice. Withdrawal, unexplained absences, physical signs, changes in behavior. If you observe any of these things in a child in your community, please trust your concern. Contact the Child Help National Child Abuse Hotline at 1-800-422-4453. Your call is confidential and it could save a life. Please like this video. Sophia Pedroso deserved protection. Telling her story honestly is one small way of honoring what she was owed. Case 9, Cara Rintala. March 28, 2010, crime. February 2023, final plea. Hampshire County Superior Court, Granby, Massachusetts. Hampshire County sits in the Pioneer Valley of western Massachusetts, a region of broad river plains, academic communities, and small towns whose rural character provides a counterpoint to the more densely populated eastern part of the state. It is a region known for a particular kind of progressive, community-minded civic culture, shaped in significant part by the presence of several major universities and a long tradition of civic engagement. Granby is one of the small towns in Hampshire County, a rural community of roughly 6,000 people where the pace of life is measured and where the loss of a community member, whatever the circumstances, is felt personally by people who were likely to have known the person directly. Anna-Marie Rintola was 35 years old. She lived in Granby with her wife, Cara Rintola, in a home that was part of the ordinary fabric of the town. Cara was a trained paramedic, a person whose professional identity was built entirely around the preservation of life, around arriving at emergencies and doing everything that training and instinct and equipment could provide to keep people alive. It was, in retrospect, an element of the case that many people who followed it found deeply significant, not in the sense that it changed the facts, but in the sense that it added a particular dimension of irony and tragedy to a story that already had both in abundance. On March 28, 2010, Cara Rintola called emergency services. She reported that Anna-Marie had been found unresponsive inside their Granby home. First responders arrived and found Anna-Marie in a condition that, once the medical examiner had completed their analysis, was determined not to be the result of a natural event. The medical examiner's findings established that Anna-Marie Rintola had lost her life as the result of strangulation. That determination transformed what had initially been responded to as a medical emergency into a criminal investigation. And that investigation, from its earliest stages, focused on the person who had placed the original call. Cara Rintola was charged with the murder of her wife. The case that followed became one of the longest and most procedurally complex prosecutions in the modern history of Hampshire County, a case defined not by a single dramatic outcome, but by a sequence of legal proceedings that stretched across 13 years and tested every component of the criminal justice system's capacity for sustained engagement with contested evidence. The first trial ended in a hung jury. 12 people examined the evidence and could not reach a unanimous verdict. The case went back to the beginning. The second trial also ended in a hung jury. Again, the jury deadlocked. The case went back again. The third trial produced a conviction, a guilty verdict that Rintola's defense team immediately challenged through the appeals process. The Massachusetts Appeals Court eventually overturned that conviction on grounds related to the admission of specific evidence during the proceedings, a ruling that, whatever its legal basis, meant that the case would need to be tried again. By the time the legal process had arrived at the prospect of a fourth trial, more than a decade had passed since the evening of March 28, 2010. Witnesses who had been present and coherent in 2010 were working from memories that 13 years of time had inevitably affected. The evidence record had been shaped and reshaped by years of legal challenge and appellate review. The practical and financial costs of yet another full trial were significant, and both the prosecution and the defense arrived, in February of 2023, at a resolution that neither had originally sought. Cara Rintola pleaded guilty to voluntary manslaughter. She received a sentence of time served and was released. Having spent significant periods in custody during various phases of the prosecution, the time-served sentence meant that she walked out of the legal system without additional incarceration. The plea did not constitute an admission of murder. It constituted an admission of responsibility for Anna-Marie's passing at a level that the plea negotiations, shaped by 13 years of legal history, reflected as the achievable legal conclusion. The response to the plea and its outcome was as varied as the perspectives of the people who had followed the case through its full 13-year span. For those who had always believed that Cara Rintola had been responsible for her wife's passing and that a murder conviction was the appropriate legal response, the manslaughter plea and the time-served sentence represented a deeply inadequate conclusion. For those who had, over the course of multiple trials and hung juries, maintained that the evidence had never fully supported the original charges, the resolution carried a different weight, neither a complete vindication nor a clear expression of justice, but a recognition that the available legal tools had been applied to their limit. What is beyond any legal debate is that Anna-Marie Rintola passed away on the evening of March 28, 2010, in her own home, in a town where she had built connections and relationships and a life. That her passing was not natural. That the circumstances of it were contested in a court of law for 13 years, and that the person she had chosen to build her life with, her wife, her partner, the person whose presence in her home should have represented the most fundamental guarantee of her safety, was the person who ultimately pleaded guilty to responsibility for her passing. 13 years of legal proceedings is an extraordinary span of time for a family waiting for resolution. Grief, as anyone who has experienced it understands, does not pause for retrials or appellate decisions. It continues, quietly and persistently, regardless of what is happening in a courtroom. The people who loved Anna-Marie Rintoula, her family, her friends, the people who had known her before she became the central figure in a legal case that would outlast most courtroom careers, lived with an absence that the legal system, despite its 13-year effort, could only partially address. Anna-Marie Rintoula was 35 years old. She had her adult life fully in front of her. She had a community she was part of and a home she had built. She is remembered here not as a footnote in a discussion about evidentiary standards or as a procedural reference point in debates about the insanity defense, but as a person whose life was real and whose passing was a loss that deserved honest accounting, and that, however incompletely, the legal system spent 13 years attempting to provide. If you have experienced harm within a relationship or are concerned about a situation involving relationship-based safety, please reach out to the National Domestic Violence Hotline at 1-800-799-7233. Support is available around the clock, confidentially. Please like this video. 13 years later, Anna-Marie Rintoula's story still deserves to be heard. Your support ensures it reaches people who need it. Case 10, Suzanne Hardy. August 2014, crime. March 2019, SJC ruling. Hampton County Superior Court, Springfield, Massachusetts. Hampton County anchors the southwestern corner of Massachusetts, a region centered on Springfield, the state's third-largest city, and extending outward through a mix of mid-sized communities, suburban towns, and rural stretches where the pace of life carries a different character from the more densely populated parts of the state. Springfield is one of those smaller communities, a town in the hill country east of Springfield, known perhaps most widely for the enormous antique market that draws visitors from across New England several times a year, and for the kind of quiet, unassuming community life that characterizes rural western Massachusetts. In the summer of 2014, a car crash in Springfield set off a chain of legal events that would ultimately reach the Massachusetts Supreme Judicial Court and produce a ruling that generated significant attention in both child safety advocacy and legal scholarship. A ruling that drew a precise and consequential line between two legal concepts whose distinction, in this case, had life or death significance. Dylan Hardy was 4 years old. Jace Hardy was 1 year old. They were nephews of Suzanne Hardy, and on the day of the crash, they were passengers in her vehicle. The collision occurred on a summer day in Springfield. When emergency responders arrived at the scene, they found both children had sustained severe injuries. Neither Dylan nor Jace survived. The investigation that followed the crash identified a critical element of what had happened. The children had not been properly secured in age-appropriate child safety seats at the time of the collision. Dylan, who was 4 years old and required a booster seat appropriate for his age and size, was not in such a seat. Jace, who was 1 year old and required a properly installed infant seat, was not properly restrained. The absence of appropriate restraints was a significant factor in the severity of the harm both children sustained when the collision occurred. Suzanne Hardy was charged with manslaughter in connection with the passing of both boys. The prosecution's argument rested on a specific and legally demanding foundation, that Hardy's failure to properly restrain the children in her care was not merely careless, not merely the ordinary kind of human failure that constitutes negligence, but that it rose to the legal level of recklessness. Under Massachusetts criminal law, manslaughter requires recklessness, a conscious disregard of a substantial and unjustifiable risk, a deviation from the standard of care so significant that it represents a different category of culpable behavior from ordinary negligence. The jury in Hampton County heard the evidence and convicted Hardy on both counts of manslaughter. She was sentenced accordingly. The conviction stood for several years as the case moved through the appellate process. And then, in March of 2019, the Massachusetts Supreme Judicial Court issued its ruling. The court's analysis was precise and legally grounded. The justices examined the distinction between negligence and recklessness with the exactness that the highest court in the Commonwealth is equipped to apply. Their conclusion was that while Hardy's failure to properly secure Dylan and Jace in appropriate safety restraints was clearly negligent, a clear departure from the standard of care that any responsible adult transporting young children in a vehicle was required to meet, it did not, based on the specific facts of this case and the legal standard applicable to the manslaughter statute, rise to the level of recklessness that criminal conviction required. The convictions were overturned. A new trial on the manslaughter charges was not ordered. The ruling produced immediate and significant responses from the child safety community. Advocates argued that the practical message sent by a high court determination that failing to secure a young child in a car safety seat, a failure directly connected to 2 fatalities, did not constitute criminal recklessness was deeply concerning. They pointed to the data on child passenger safety. Car crashes are among the leading causes of injury-related passing among children in the United States, and the proper use of age-appropriate safety restraints is one of the most well-established and most consistently demonstrated protective factors available. The absence of those restraints in a crash is not a minor oversight. The consequences, as Dylan and Jace Hardy demonstrated, can be final and irreversible. Legal scholars approach the ruling from a different angle, noting that the Supreme Judicial Court's function in a case like this one was not to reach the result that felt most proportionate to the harm that had occurred, but to apply the law as it was written with the precision and consistency that the rule of law requires. Blurring the line between negligence and recklessness, they argued, would create uncertainty across a broad range of criminal proceedings and would ultimately serve neither justice nor public safety. The law's standards have to mean what they say, even when, especially when, the facts of a particular case make the consequence of applying them strictly feel inadequate. Both of those positions reflected real concerns. Neither of them addressed the most basic and irreducible fact of the Springfield case, which was that Dylan Hardy and Jace Hardy were in a vehicle on a summer day in 2014 and that they did not survive it. Dylan was 4 years old, an age defined by questions and discoveries, by the particular magic of understanding the world with increasing clarity while still experiencing it with the wonder of early childhood. Jace was 1 year old, barely past the beginning, carrying in him every possibility of a future that a 1-year-old carries, which is to say, every possibility entirely. Both of those futures ended on a road in Springfield, Massachusetts, in part because the restraints that were designed specifically to protect children of their ages were not in place. The Supreme Judicial Court's ruling did not declare what happened to Dylan and Jace acceptable. It did not declare Suzanne Hardy's conduct appropriate. It declared that the specific criminal tool used to pursue accountability in this case did not fit the specific legal standard required. That determination lives alongside the loss of 2 children as part of the same story. A story that is, finally, and at its core, about 2 little boys who were owed the protection that age-appropriate safety restraints provide and who did not receive it. Every child who rides in a vehicle has a right to be properly secured. It is not a burden. It is not an inconvenience. It is the most basic act of protection available to any adult responsible for transporting a young child. Dylan Hardy and Jace Hardy are remembered here because they deserve that protection. Because their story, told honestly, is the most direct and concrete reminder of what the data on child passenger safety actually means in human terms. For information on age-appropriate child safety seat installation and use, please visit the National Highway Traffic Safety Administration at nhtsa.gov. Proper installation matters. The few minutes it takes to verify a seat is correctly installed and a child is correctly secured are among the most important few minutes any caregiver can spend. Please like this video and subscribe to Cold Case Hour. Dylan Hardy was 4 years old. Jace Hardy was 1 year old. Remembering them and learning from what happened to them is the very least they are owed. This documentary was produced for educational and public awareness purposes by Cold Case Hour. Every case examined in this film is drawn from verified court records, medical examiner reports, and credible journalism. No case has been sensationalized. No victim has been treated as anything other than what they were, a real person whose life and whose passing deserve to be discussed with dignity, care, and honesty. The goal of Cold Case Hour has always been to ensure that the stories of victims are not reduced to tabloid headlines or shock content, that they are told with the full weight of their human significance, in a way that informs, that educates, and that contributes to the conversations our communities need to have about child safety, mental health, domestic violence, and the obligations we carry toward one another. If any element of this documentary has affected you personally, please reach out to the resources mentioned throughout this video. Postpartum Support International, the National Domestic Violence Hotline, the Child Help National Child Abuse Hotline, the Massachusetts Department of Children and Families, the National Alliance on Mental Illness Helpline. These organizations exist because the issues raised in this documentary are real, they are ongoing, and they affect families in every community across this country. If this documentary informed you, moved you, or reminded you of something important, please take a moment right now to like this video, leave a comment below sharing your thoughts so that you never miss another story. Every subscription, every like, every comment tells the platform that this kind of responsible, educational, community-focused, true crime content matters. And it does matter. These stories matter. These victims matter. And this community is how we make sure they are never forgotten.